Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Megan Neal presenting for us. If you are unfamiliar with the format of this event, first, Megan is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or in the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Be sure not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Megan to get us started.
Thanks, everyone. And thanks, Marissa. As Marissa said, my name is Megan, and I work in Legal Aid's Greensboro office, and I work on benefits cases. And that includes SSD and SSI cases, and that's what we're going to talk about today. I'm going to specifically be talking about administrative law judge hearings for disability benefits in SSI and SSDI cases. Although those two different programs, SSDI and SSI, have some different eligibility requirements, the medical definition of disability for those two programs is exactly the same. And that's mostly what's going to be evaluated in your disability hearing. So for the purposes of today, we're going to be talking about disability hearings that apply to both of these programs. And we're going to specifically be talking about adult cases, and disability for kids cases are a little bit different. So today we're just going to be focusing on adults. So let's get started. So like I said, the main thing you're trying to prove in these applications and these hearings is that you're disabled and you therefore can't work. So you might be wondering, what does disabled mean in this particular context? So here on this slide, I have the formal definition of disability from Social Security's regulations, and I'll read it to you now. Disability is the inability to do any substantial gainful activity by reason of any medically determinable physical or mental impairment, which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. So the way that I would sum that up in more kind of plain language is that you have to have a severe disability that prevents you from doing any work on a continuous, consistent, full-time basis. And the way that plays out in these cases is a little more complicated than that, but I think we can probably use that understanding for the purposes of today, and we're going to talk about it a little bit more in the next few slides. I did go over this disability standard in my presentation from last month, and that should still be on our Facebook Live page. So if you have some kind of more in-depth questions about the way Social Security thinks of disability medically, you can check that out. So just to kind of situate where we are in a case, if we have an ALJ hearing coming up, I have this chart here for you. And this chart shows the different levels of appeal that a disability application can go through. You can see that the administrative law judge hearing is kind of the third level here. And on the right side, we can see there's percentages, and those are the percentage of cases that are either allowed or denied at each different level. So, um, so let's just go through that briefly. If you can see the chart, or you can see the numbers on the chart, you can see that it's really common for a disability application to be denied at the initial level. And so as you go through the chart, you can kind of see why you should keep appealing, because your best chance of winning, at least statistically speaking, is at the ALJ level. Again, ALJ stands for Administrative Law Judge. Um, and so if you apply and you get a disapproved claim, the first step of appeal is called a request for reconsideration. That's the second level here. You can see 16% of cases are allowed at this level, 84%, unfortunately, are denied. When you request a reconsideration, the case is sent back to an office in Raleigh called the Disability Determination Services, DDS. Um, and that's the office that reviews medical evidence and medical claims for Social Security. And when you request a reconsideration, they have a different person from the first time around review your case and issue a new decision. So it's sort of getting a second look by a new person, but the same office. If your claim is denied at the reconsideration level, the next step then is going to be to request an ALJ hearing, and that's what we're talking about today. So an ALJ hearing is when you appear either in person or by phone or online video hearing before the judge. This is your chance to make your case in person before a judge who's going to review all of your medical records and any other evidence that you wish to provide in your case. If you have a representative, an attorney, that person can appear with you, and there might be a vocational expert at the hearing, and there may also be a medical expert in your hearing, although that doesn't happen super often. Again, you have the best chance of winning at this level, at least statistically speaking. And so if you see the chart, 51% of cases are approved at this level. I should note these are national numbers. This is a chart from the Social Security Administration. So depending on where you are, the statistics might be slightly different. This is sort of like national averages. If you are unsuccessful at the hearing level, you can file a request for review to the Appeals Council. This is the final level of administrative review in the process. And the Appeals Council is a panel of 3 administrative law judges who are based out of Falls Church, Virginia, and they are making a decision on the papers in your case. Is what we call a paper appeal. So there's not really an in-person appearance. They're just reviewing the judge's decision and the medical evidence in the case and the transcript of the hearing and seeing if the judge made any errors. If you are unsuccessful at the Appeals Council level, you can then file a complaint for judicial review in federal court. And I say all this just to kind of situate where the administrative law judge hearing is in the life of a disability application. It's kind of right in the middle, but arguably it's the most important step. So let's just talk for a second about appeals deadlines. Um, the most important thing you can do when you get letters from Social Security is to read them. And one of the reasons that's so important is because the letters and notices you get from Social Security, if you can appeal, the deadline is they're gonna tell you the deadline in the letter. For medical eligibility cases, you generally have 60 days to appeal plus 5 days for mailing. That's 60 days. That's 65 days from the date on the letter. Um, so if your request for reconsideration is denied, you're going to want to take a look at that letter. You're going to want to take a look at the date of the letter, and then you can appeal within 65 days of the date on that letter. If you are later than that, you can still appeal, but you'll need to have a good reason. You'll need to have good cause for submitting a late appeal. A typical example of good cause would be, let's say you were very sick and you were in the hospital for much of your appeal period, and you didn't get the letter because you were in the hospital. You would want to explain this to Social Security and ask that you be allowed to submit a late appeal because you have good cause. Um, So when you're filing an appeal, you can do this a couple different ways. You can appeal on Social Security's website, which is ssa.gov. You want to make sure if you do that, you print out or save the screen that pops up showing the date and time that you submitted your appeal. Another way you can submit your appeal is by going to your local office and completing the appeal form, getting a date stamped copy from them showing that you submitted the form. If you're having trouble with this, you can also call them and ask for help, and they're supposed to help you submit your appeal. But I think the most important thing you can do whenever you're submitting anything to Social Security, and especially when you're submitting appeals, is to make sure to keep your own proof showing when you submitted the appeal. So again, that might be a date stamped copy of what you submitted, or if you did it online, you'll want to print out the screen that pops up showing when you submitted it. So let's talk a little bit about preparing for your hearing. So one of the first questions someone might ask is, should I get an attorney for this hearing? That's your choice. Our opinion is that generally you're going to be better off if you have an attorney representing you. That being said, you absolutely can, and many people do represent themselves. You can try to get a private attorney. Private attorneys, private attorneys get fees on what's called a contingency basis. So if they win your case, they're going to get paid from your retroactive Social Security benefits. And they can get up to 25% of your retroactive benefits. That's going to be capped at $9,200. Our office, Legal Aid, does not charge a fee. So if you live in North Carolina and you can't find an attorney from the private bar to represent you, you've been turned down by 2 private attorneys, you can call our office and we might be able to help you if you meet our income and eligibility requirements, and if the local legal aid office has the resources to help you at that time. Again, we don't charge a fee. But if you can't find an attorney to help you, you can represent yourself. And like I said, many people do. Remember that, based on that chart we were looking at earlier, this is your best chance to get approved. at least statistically speaking. So you want to make sure to prepare ahead of time for your case and to take that preparation seriously. You're going to want to gather all of your medical evidence, which means primarily medical records, and submit them to the hearing office 5 business days before the hearing. And that's kind of the latest that you should be submitting your medical records. If you have them earlier, definitely submit them earlier. Another thing you can do is you can get a copy of your hearing file from the hearing office and you can review it. So you can call the hearing office that is going to be listed in the letters you receive from them. And the contact info should be on the upper right-hand corner of the first page of any letters you get from the hearing office that your case is ultimately assigned to. So you can get this file, you can review it. You want to make sure that your file is complete and that Social Security has all of the necessary evidence for your case. Evidence, again, it's going to be primarily medical records. You're going to let Social Security know if anything is missing. Another thing you can do is, if you can try to get a written medical opinion from your treating doctor. You could ask them to write a letter about your medical limitations and to explain to the judge why they, your doctor, think that you can't work. You could also try to get a third-party witness statement from like a close family friend or family member or employer or former employer. And that person could give their firsthand observations about your daily limitations. So again, your hearing is going to be happening at the hearing office that your case is assigned to, and you're going to be given at least 75 days in advance, 75 days notice in advance of when your hearing is scheduled. So you should have time to prepare. There's 4 different ways that you can appear at your hearing. You can appear in person. You can appear by agency video, which is when you go to your local, one of your local offices, and the judge kind of appears by on a video, but you're going to be located at a Social Security office. You can appear by online video, which is done through Microsoft Teams, which is basically like Zoom. Or you can have an audio hearing, which is on the phone. So the way you can learn more about these options and exercise your preferences is after you request your hearing, you're going to get some letters back from the hearing office. And one of those letters that you get is going to give you the option about these different ways to appear. And they're going to kind of explain in more depth what each way is like. And you're going to have the opportunity, they're going to send you 2 different forms. You're going to have the opportunity to object to appearing by phone or agency video. And you'll also be given the opportunity to agree to appear by online video. So you'll take a look at that. You'll fill those out and exercise your preferences, and then you'll send that form back. And that should help to dictate how your hearing is held. So at the hearing, the big thing the judge is going to be thinking about and trying to get through is what is called the Social Security's 5-step sequential evaluation process. And this is the process that Social Security uses to determine if someone is disabled. I did go over this in some more depth in my last presentation, which, like I said, is currently on our Facebook Live. But let's just go through this briefly so you can have an idea of what questions the judge is trying to answer in the hearing, and specifically will be trying to answer when they write their hearing decision. So Social Security asks these 5 different questions to determine if you're disabled. They are sequential, meaning they go in order one after the other. So the first question they're asking is, are you currently working? If you are working, are your earnings above the income threshold that the government calls SGA? That stands for substantial gainful activity. In 2026, that income threshold for non-blind individuals is 1,690, and for blind individuals, it is 2,830. And these levels change every year, and you can find the updated levels on the SSA.gov website pretty easily. So if the answer to this question is yes, you are working above the SGA level, then unfortunately, Social Security will find that you're not disabled. But if the answer is no, you are not working above this level, you'll be able to move on to the next step of the sequential evaluation process. So step 2 asks, do you have a severe impairment or combination of impairments that meets Social Security's duration requirement? So in this step, they want to make sure that you have a medical diagnosis from an acceptable medical source. So that's like a doctor or a psychologist, that at least minimally affects your ability to engage in work-related activities. And this medical condition must have lasted or be expected to last 12 months or to result in death. If yes, you do have this severe medically determinable impairment, you're going to move on to the next step. Step 3 is, does your medical condition meet or equal one of Social Security's listings? So the Social Security Administration has published listings of all these different medical conditions with very specific criteria attached to them. And if you meet one of those, Social Security will find that you meet the medical definition of disability at this step, and your disability case would be approved if you meet one of those listings. But if you don't, and they can be difficult to meet, that's okay. You can just move on to the next step because there are other ways to be found disabled. After this, Social Security is going to have to determine what's called your RFC, your residual functional capacity. And that is what is the most that the judge thinks you can do based on your physical and mental impairments. So after they've figured this out, they're going to move on to step 4, which is looking at your past relevant work. And that means your past work over the last 5 years. They're going to look at it and they're going to compare that work with your RFC and say, are you still able to do your past work? So if the answer is yes, you can still do your past work, then they're going to find that you're not disabled. But if the answer is no, you cannot still do your past work, you're going to move on to the last and final step. And step 5 is considering your residual functional capacity and your other medical vocational factors. So that's like your age, skills, education. Can you do any other work that exists in the national economy in significant number? So in other words, are there any other jobs that you can do in the economy on a sustained basis, given your physical and mental limitations? If there's no other work you can do, then you do meet the definition of disability. And there will probably be a vocational expert at your hearing. So the vocational expert is going to play a role in helping um, the judge determine if there are other jobs that you can do in the economy. Okay, so just again, that's what's going on in the background of the judge's mind when they're conducting the hearing. Okay, so at the hearing, um, who's going to be there? So the judge will be there. You, the claimant, will be there. You're kind of the main witness. You're going to be testifying at your hearing. A hearing reporter is going to be there, and that person is going to be typing to record what's happening in the hearing so that Social Security can keep a record in case there's an appeal. Like I said, most hearings will have a vocational expert. The vocational expert, they typically appear by phone kind of regardless of what type of hearing you have. So if your hearing's in person, they'll probably be on the phone. If your hearing is on Teams, they'll probably be on the phone. Like I said, they're going to play a role at steps 4 and 5 in determining your past relevant work and if there are any jobs in the economy that you can do. And the way they're going to do this is the judge is going to ask them a bunch of questions, and you or your attorney can also ask the vocational expert questions. But the questions are going to primarily be around the issue of, can someone who has limitations that are similar to yours do your past relevant work or any other work in the economy? And from time to time, you might have a medical expert who is a doctor and will testify more about the diagnoses that you have. This would not be your doctor. This is a doctor that the Social Security Administration pays. But it's not super common to have a medical expert at hearings. You should know that these hearings are completely confidential. No one in the room during your hearing can disclose to anyone else what happened without your consent. Again, there is a record that's being taken in case there's an appeal. So at the hearing, you're going to provide testimony to the judge. And the way you'll do this is by answering the judge's questions, or if you have a representative, your representative will also ask you questions to kind of get out your testimony. So when you're doing that, you have a chance to tell the judge why you're there, why you think you're disabled, why you think you can't work, what medical impairments you have, and how they affect your day-to-day life. You're going to be going through your work history. The vocational expert might ask you some questions about your work history, your educational history, and other things that might relate to different related abilities that you can or cannot do. So after all that, the judge will issue a written decision. And again, that written decision is going to kind of be summarizing the medical records, what was discussed in the hearing, and the judge is kind of going to try to be answering those 5 questions that we just went over. it could take months for you to get the decision, or weeks. Unfortunately, there's not really a set time that they have to, or a set timeline that they have to follow. But I would say your decision should come in weeks to months. Again, you want to be, it's going to come in the mail, so you want to be checking your mailbox, looking at it promptly. And then if your case is approved, congratulations. If it's denied, you have appeal rights to appeal that decision to the appeals council if you need to. And that is it. Let us know what your questions are, or if there's any other Social Security topics you want to learn about. And I have our contact info, our phone number, and the hours during which you can call our helpline to if you think you might have a case for us to review. And you can also check out our website. We're not currently doing intake on the website, but you can give us a call if you want to try to get us to review your case.
Awesome. And so we do have a couple questions in the chat here. As mentioned, if you have a question, you either need to type it in the Q&A box on Zoom or put it in the comment section on Facebook. I did respond already to the question asking for the link, and it's also in the chat, to the most recent presentation that Megan went over, where she described, I think, what it means to be disabled under the Social Security Act. A link to that presentation is in the chat for you all to review. First question. Someone's asking if they qualify for legal aid, sir, if they meet the eligibility requirements, do they still have to be denied by two private attorneys to potentially seek legal aid representation?
Um, the answer is yes. I don't know, Marissa, if you want to say any more about that.
Um,
But yes, you have to be denied by two private attorneys for if your case is a initial application for disability, then yeah, you'd have to be denied by two private attorneys.
yeah, and I'll agree with that response. And if there's a question about where you are in the process, you are always welcome to call into our helpline to see if wherever you are, if you qualify for services at that time. But essentially what Megan said is correct. You have to be denied by two private attorneys. Um, Next question, and this might be a little bit more opinion based. Has the idea of remote work impacted what I guess the employment expert who comes in and they say, is there any other work? How has remote work changed what's considered available work in the national economy? I think that makes sense. Let me know
Yeah,
if I need to
I
clarify.
that's a great question. I worry about this all the time. And the short answer is it has not affected it yet. Um, and the reason is because a lot of the information that Social Security uses to determine the availability of other jobs in the economy is not super up to date, I would say. So the I think the remote jobs thing has really just become a little more common in the past few years, and Social Security's jobs data, I would say, is not that up to date.
Perfect. Well, as I am not seeing any more questions, I'm going to go ahead and thank you all for joining us with a very special thank you to Megan for presenting and for answering those questions. If you would like to review anything that Megan has discussed today, you can watch a recording of this event on our Facebook page. It will be immediately available following the event. You can access the recording with or without a Facebook account at www.facebook.com/legalaidnc. The recording will be available for about 30 days, but in about a week, it should be available on our YouTube to watch at any time. If you would like to register for one of our other Listen and Learn programs, such as child custody, criminal record expungement, you can do so on our Eventbrite page or on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their afternoon.
Thank you. Bye.